Well, my dear friends, this is a difficult day, of course, for myself and my family and all of my good friends.
In the nation's capital, a momentous legal case is unfolding.
This trial will enable the Australian people to indicate the moral and political values that they expect from their political leaders.
The man at the centre of it, a lawyer and former ACT Attorney-General, could soon be facing a jail sentence.
Usually, traditionally, it's simply not in the public interest to prosecute this kind of thing.
There is that, I think, overall perception that this sort of litigation is a payback, firstly. Secondly, that the secrecy provisions are perceived to be a cover-up.
I fear we're living in very dangerous times here in Australia. There is clearly a reduction in civil liberties. I would characterise it as being in a pre-police state.
Bernard Collaery and a former spy known as Witness K helped expose one of Australia's most controversial intelligence operations, in which Australian secret agents bugged the government of one of our closest allies.
It was very ugly. It's not worthy of Australia as a rich, democratic country. It's not what we knew about Australia, fair-minded people, a fair-minded society.
I think it is about the most despicable piece of trickery that I know of that Australia has committed.
15 years later, that secret operation is about to have its sequel in what could be one of the most secretive trials in Australian history. It's a trial not of those who hatched the plan to bug this building, but of the two men accused of revealing it happened. Tonight on Four Corners, the extraordinary steps the Australian government is taking to punish these men and to keep them silent.
This is a very, very determined push to hide dirty political linen. That's what this is all about, dirty political linen under the guise now of national security imperatives.
In 2004, in Canberra, as winter crept up on the capital, one of the top surveillance experts with Australia's Foreign Intelligence Service, ACIS, was called into a secret meeting. The agent was ordered to undertake a mission that would change his life forever and become one of the most infamous spying operations in Australian history. He was told to bug the office of the Prime Minister of one of our closest neighbours, the new nation of Timor Leste, formerly known as East Timor.
Well, by now it's been well reported that in 2004, the Australian Secret Intelligence Service bugged the East Timorese in order to give Australia an unfair advantage during the treaty negotiations that were going on at that time.
It was done under the cover of an aid project.
The Australian government was offering assistance to East Timor. And one of the ways it offered assistance was to refurbish the Prime Minister's residence in Timor and his offices. And that was under an AUSAID program.
The bugging of the Prime Minister's office in Timor Leste occurred at a very difficult time for the government of Timor Leste. They were a fledgling government. They'd just come out of the US mandate, just got independence.
After decades of struggle, Timor-Leste had gained its hard-fought independence from Indonesia in 2002. Its new leaders faced the massive task of rebuilding the country.
Timor had just come out of a genocide. They had lost 31% of their population during the Indonesian occupation of Timor. That's the largest loss of life relative to population since the Holocaust.
Timor was a destroyed country at this stage. I saw with my own eyes the destruction of Timor, and I have seen the Australian government's assessment of the infrastructure destruction, and it varies from 20% in some areas to the capital, Dili, being 100% destruction. The whole thing was destroyed, all the public buildings and the services for the people.
Sister Susan Connolly had been working on aid projects in Timor Leste since the 1990s.
The poverty and malnutrition really was huge. I met people who really were lucky if they had a meal a day.
The best hope for this poor country were tens of billions of dollars worth of oil and gas that lay beneath the floor of the Timor Sea.
East Timor was really desperate for a good deal with Australia.
In April 2004, negotiations between the two countries began in Dili to resolve who owned the vast oil and gas fields. Already there was bad blood after Australia had withdrawn from the International Court of Justice's jurisdiction, resolving maritime boundaries.
By withdrawing from the mandatory jurisdiction of the International Court of Justice, Australia, in effect, forced East Timor to negotiate.
Withdrawing from the jurisdiction, compulsory jurisdiction of ICJ. Here you have only Donald Trump does these things. You wouldn't expect previously any other country doing that.
In addition to blocking a judicial resolution of our maritime dispute.
At the first round of talks, Timor Leste's Prime Minister Mari Alkatiri came out swinging.
For us, a 20-year negotiation is not an option. Timor Leste loses $1 million a day due to the Australian unlawful exploitation of resources in the disputed area. Timor Leste cannot be deprived of its rights or territory because of a crime. Thank you.
He was so annoyed with Alkatiri.
Thanks, Prime Minister.
Because Alkatiri was a tough negotiator, a man of principles, and so he really annoyed John Howard, annoyed Alexander Downer.
This is my style.
I think they've made a very big mistake thinking that the best way to handle this negotiation is trying to shame Australia, is mounting abuse on our country, accusing us of being bullying and rich and so on, when you consider all we've done for East Timor.
We wanted to say that this is really important to East Timor. We wanted to put it in their face. We didn't want to have negotiations that lasted 30 years.
Peter Galbraith, a former US ambassador, was Timor Leste's lead negotiator in the talks.
I was very concerned about Australian intercepts of cell phones, including cell phones when they weren't being used, but were still on, and I was very concerned about intercepts of emails. But I did not imagine, one, that they would break into a building and bug it, or that they would have access to the building to bug it.
It was during a 6-month halt in negotiations that a team of ACES agents arrived in Dili to install covert listening devices inside Timor Leste's Palace of Government.
I understand that the bugs were placed in. The conversations were then beamed via a line-of-sight microwave transmission to a listening post, which is about 500 meters away.
Their listening post was in a floating hotel in Dili Harbour called the Central Maritime Hotel.
That listening post collected the transmissions, and then they were then couriered across town to the Australian Embassy, so that our negotiating team would have had real-time access to the internal deliberations of the Timorese side.
Successive Australian governments have refused to confirm or deny that this spying operation took place.
An operation like this would need to have been authorized by the National Security Committee of Cabinet, ordered in turn by the responsible minister, the Foreign Minister Alexander Downer, and then the direct order to Witness K would come from the Director General of ACES, David Irvine. The greatest benefit that Australia would have achieved from the bugging is to know what East Timor's bottom line is, what we were prepared to settle for, because once you know that, then you never have to offer anything more. Your entire negotiating strategy is to go below the bottom line.
The war is over. Australia helped restoring Timor freedom, peace. We are negotiating in good faith as mature adults, and then they bug our offices to try to obtain advantages in the negotiations.
When I think back now, that here we were talking to schools, running concerts, sending out messages in newsletters saying, give us money, give us money, give us money all the time. At the same time, our government is plotting and implementing a fraud against these very same people. Because Timor is really important to a lot of Australians. Because we know we sold them out in 1975. We haven't paid the Second World War debt. And here we are in our name, in my name, governments, foreign ministers, various ones would stoop so low as to spy on their negotiators under the guise of a taxpayer-funded refurbishment. It is despicable, that's all I can say.
After 2 years of intense negotiations, a deal was signed in 2006.
Well done, Alexander. Well, very significant moment, but we might say something to the media about it.
Advocates for Timor Leste say the bugging swung the final deal in Australia's favour.
This is an oil and gas field in between Australia and Timor, which is located 150 kilometres from Timor-Leste shore and 400 kilometres from Australia's shore. And yet, because of this industrial espionage, the deal came out as 50-50. Now, no drawing of any maritime boundary anywhere in the world between two countries would result in that sort of outcome.
As if Australia didn't have enough oil, enough gas, and enough money, trillions of dollars economy, and still wanted, us to accept their continental shelf claims and give to them all of Greater Sunrise, all of the Timor Sea.
The bugging operation is likely to have remained a secret, except for one man. He was the head of technical operations for ACIS and the team leader of the Dili bugging operation. His identity is top secret. He's now known as Witness K.
This is not a person who goes, as it were, to the tabloids or the scandal sheets and then tries to cover up with a fig leaf of public interest. This is the very opposite of all of that.
Brett Walker is the former independent monitor of Australia's national security legislation and has previously acted for Witness K.
Confining myself to the public record, it's clear that Witness K is the kind of person in whose favour there will be lots able to be said about a long, honourable career, making him a person who's rendered great service to this country, who is now being prosecuted as if he has committed a great disservice to the country.
Witness K retired from ACIS after a long career in late 2006. 2 years later, he took a grievance about being sidelined and passed over for promotion to the Inspector General of Intelligence and Security. He was given clearance to consult a lawyer. The lawyer he chose was Bernard Collaery.
Canberra is a very small place. Bernard Collaery is the former Attorney-General of the ACT. But ACIS has always known about Collaery's commitment to the right of self-determination of the people of East Timor.
Bernard Collaery has worked with the Timorese in legal cases since the 1980s and has also been given clearance to represent members of the Australian intelligence community.
Bernard Collaery is not just some two-bit lawyer from up the street, just on the make. He has been the Attorney-General of the Australian Capital Territory. He has held high position. He is highly respected, not only in Canberra but across Australia and internationally. The Timorese certainly hold him in high regard.
Bernard Collaery met with witness K in 2008 to discuss his grievance. Collaery later made a written statement to the Senate about what witness K told him.
Witness K alleged he had been constructively dismissed from ACES as a result of a new culture within ACES. The evidence indicates that the change sought included an operation he had been ordered to execute in Dili, Timor Leste.
Bernard Collaery is now restricted in what he can say because of his upcoming trial. But in 2015, he said witness K was appalled by the bugging operation.
I recall in my instructions a mention being made of the infant mortality rate. So this was a morally based grievance, not on lost promotion or the end of a career, which in my view was a very legitimate grievance, but it was a grievance based on the immorality of that conduct.
Prime Minister Xanana Gusmao found out about the bugging, and in late 2012 told Australian Prime Minister Julia Gillard that he knew about the operation and wanted the treaty invalidated.
I sent a letter to her, and she said, no, we didn't. We didn't. I continued to insist.
Do you think she didn't know that this operation took place?
I believe so. I believe so. I believe so. Shannon is incredibly intelligent. He studied the issues. He had been studying it from day one. He was looking for an opportunity. So Australia handed over to Shannon the angle, the excuse, the window of opportunity that Shannon was looking to challenge the Timor Sea Treaty.
In April 2013, Timor Leste launched a case in the Permanent Court of Arbitration to overturn the treaty, with Bernard Collaery as one of their lawyers. It was the Australian government who revealed that the case was based on allegations of espionage.
East Timor is going to arbitration and accusing Australia of past espionage in the process.
Well, that's the allegation, that in the course of negotiating this treaty back in 2004, Australian officials were aware of confidential information belonging to the Timorese negotiating team, and we can't comment further on the matter.
Timor Leste now had the upper hand. Armed with knowledge of the bugging, they could make the case that the treaty should be torn up due to negotiations held in bad faith.
You are negotiating, and rules say you don't do these things. You are caught, negotiations finish.
Bernard Collaery headed to The Hague in December 2013 to prepare for the hearings. Back in Australia, the authorities made an extraordinary move. Officers from ASIO and the AFP were sent in to raid Collaery's home and office while he was out of the country.
At about between 9 and 9:30 in the morning, there were about 10 to 15 officers at the door. They told me as soon as I opened the door that they had a warrant. There were parts that were blacked out on it, which I couldn't read. And I was denied a copy due to national security reasons.
Agents seized confidential legal documents, including a copy of an affidavit by witness K about the bugging. In a raid on witness K's home, his passport was seized, preventing him from travelling to The Hague.
I was horrified. You have two parties engaged in litigation, and one party decides that it will raid the solicitor's office of the other party, seize its documents, and prevent its witness from coming to the court. It's the sort of behaviour which in an Australian court would be regarded as a most serious contempt, which would almost certainly lead to a lengthy jail term.
You won't be surprised to know that by and large parties are not allowed to ransack the files of the other party in any litigation, including international litigation.
Bernard Collaery was furious about the raids.
This was an attempt to intimidate our witness and to prevent the evidence going forward at The Hague of this conduct. Nothing else is coming out of this case but that there was an operation in league with aid programs to construct listening devices into the walls of a building in Timor to be used by the new government. What threat to Australia's intelligence integrity does that disclosure give?
Senator Brandis.
Thank you, Mr President. I seek leave
In the Senate, the day after the raids, the Attorney-General George Brandis dismissed Collaery's claims.
Last night, rather wild and injudicious claims were made by Mr Collaery that the purpose for which the search warrants were issued was to somehow impede or subvert the arbitration. Those claims are wrong. The search warrants were issued on the advice and at the request of ASIO to protect Australia's national security.
Astonished by the raids and the seizure of its legal documents from Collaery's office, Timor Leste rushed to the International Court of Justice, accusing Australia of breaching lawyer-client privilege and violating its rights and sovereignty under international law.
Good morning. Please be seated. That has caused deep offence and shock in my country. It is that brings us here to this great hall of justice to seek justice from the World Court over the seized documents and data.
Australia had clandestinely been intercepting the internal discussions of the Timorese government by means of bugging devices.
In a stunning decision, the International Court ruled that Australia could not access the documents it had confiscated from Collaery.
By 15 votes to 1, Australia shall not interfere in any way in communications between Timor Leste and its legal advisors.
It was seriously humiliating and an indication of what each of the judges who voted in favour of imposing those orders on Australia thought about Australia's conduct.
After a year, Australia agreed to hand back Timor Leste's legal documents, and Timor dropped its case about the raids.
We'll never know how the ICJ would have decided that case because East Timor was satisfied ultimately with the return that was made to it of documents by Australia. Some very powerful arguments were put on behalf of East Timor concerning the inappropriateness of that conduct by Australia.
In March last year, the two countries finally resolved their long-running dispute, signing a new agreement over a permanent maritime boundary.
This treaty reflects a new chapter in Australia-Timor Leste relations. Congratulations to all involved in this process.
We thought that when we withdraw the complaint against Australia from the International Court of Justice, that Australia would also likewise not only negotiate with us, but would forget about witness K and Bernard Collaery.
But Australian authorities had not forgotten about the spy and his lawyer.
I was cooking a meal here one evening and two police officers came to the door. I thought it was in relation to another case I was pursuing at the time, and I got served with a summons, and I found that to be an understatement to say a surprise. It was, I was dismayed, to be quite frank. This was a summons alleging that in providing professional legal advice, I had become an accused criminal.
14 years after the spying operation and 4.5 years after their homes were raided, Bernard Collaery and witness K were facing prosecution.
I let my dinner go cold. I went upstairs and I had to apply the medicine I had told a generation of clients accused of criminal activity to myself, to focus on their betterment, to be positive, not to create worry in their families and the rest. And I said to myself, I've got to apply my own medicine. I'm going to face almost certainly a trial in this matter.
On that same evening, witness K had also been issued with a summons.
I just knew, probably, how he would be feeling. The officers told me they'd just served similar process on my client, and I felt as unimaginably, unprecedentedly, such a duty and obligation to that person.
The plan to charge witness K and Collaery remained secret until Andrew Wilkie disclosed it under parliamentary privilege.
Deputy Speaker, Australia bugged East Timor's cabinet rooms during the 2004 bilateral negotiations over the Timor Sea Treaty. The operation was illegal, unscrupulous and remains unresolved. Now, Deputy Speaker, I can explain today that the scandal has just gotten a whole lot worse because the Turnbull government has now moved to prosecute the intelligence officer who blew the whistle on the secret operation, along with his legal counsel, Bernard Collaery.
Collaery and witness K were accused of breaching the Criminal Code and the Intelligence Services Act by conspiring to communicate secret information to the government of Timor Leste. Bernard Collaery was also accused of disclosing restricted information in media interviews with 5 ABC journalists.
It's intimidation. Intimidation of ACT agents, intimidation of journalists against matters of this kind. It's an act of vengeance directed at the people who chose to expose Australia's appalling behaviour.
In intelligence cases like this, the prosecution has to have the consent of the Attorney-General. It's only the second time that consent has been granted under the Intelligence Services Act. The public interest of any prosecution has to be considered.
In matters of this type, there's a requirement to have the consent of the Attorney-General, but the decision to prosecute was an independent decision made by the Commonwealth Director of Public Prosecutions based on their consideration of the evidence, the law and their prosecution policy and guidelines.
It'd be nice to know why the Attorney-General, Christian Porter, thought it was in the public interest to proceed on these matters against witness K and Bernard Collaery. I mean, if it was right and proper to proceed, they would have proceeded at the point at which they had this material, which was several years ago.
The Commonwealth DPP first sought consent to prosecute back in September 2015, when George Brandis was Attorney-General. For over 2 years, he considered advice from 2 different CDPPs and the Solicitor-General. Brandis left office in December 2017 to become High Commissioner to London. He never provided consent to prosecute.
Well, I imagine the former attorney, Senator Brandis, didn't find this a straightforward case to say yes to. If I may say so, as a matter of my opinion, I'm not quite sure why it wasn't a straightforward case to say no to, but that's just my opinion. But on any view of it, that's a very long time for something to be sitting on an attorney's desk. I imagine it was not for want of thinking about it that time elapsed.
Within 6 months of becoming Attorney-General, Christian Porter consented to a prosecution, something his predecessor didn't do in the 2 years and 3 months after he first got advice from the DPP. Four Corners understands that the former Attorney-General George Brandis had misgivings about approving a prosecution and that there were divisions amongst the national security agencies about the wisdom of prosecuting Bernard Collaery and witness K.
The suggestion that the former Attorney-General had misgivings about pursuing witness K and Bernard Collaery, it rings true to me because there was no sensible reason for pursuing it at the time.
Agencies would be making their case that it's necessary to protect our methods and the confidentiality of our people to prevent other potential whistleblowers like witness K from coming forward and disclosing information, classified information about ACT activities. That's what they want to prevent.
Former intelligence analyst Alan Dupont worked as an advisor for Jose Ramos Horta for 10 years. but he has little sympathy for witness K.
You can't really allow people to make individual judgments about the morality or efficacy of their work when they voluntarily join and then take it upon themselves to disclose information that is privileged to them because they've been working there. So, you know, I tend to understand where the intelligence agencies are coming from and the need to protect these confidentialities, because if you have everybody going out and saying, well, I don't agree with something, and disclosing privileged information, then you don't have an intelligence service.
Drop the charges now! Drop the charges now! Hands off!
Just weeks ago, Bernard Collaery made his way into the ACT Magistrates Court.
Hey!
Little did his supporters know that this case was about to take a shock turn.
Well, my dear friends, this is a difficult day, of course, for myself and my family and all of my good friends.
Bernard Collaery had just heard in court that his former client and co-accused witness K was intending to plead guilty.
I have great empathy for witness K and the struggle that witness K has gone through, both spiritually, mentally and physically. I can understand exactly the position. After 6 long years, witness K has found the position to be.
Witness K intends to plead guilty, but only if the prosecution accepts that his sole breach was to prepare an affidavit for the arbitration hearings in The Hague.
That is, for an onlooker, a fascinating, sharp focus to bring to an allegation of offending by releasing material supposedly that should not be released, because the focus is on it being presented for the administration of justice.
This is a very, very determined push to hide dirty political linen. That's what this is all about. Dirty political linen under the guise now of national security imperatives. Is it decent?
Bernard Collaery is vowing to fight on, but the public may never know the full story of the evidence heard against him.
Thank you.
This could be, in a strange way, one of the most secretive trials in Australian history. There are some obvious national security matters where protection is required, but where is the national security elsewhere in the proceedings? And because that's being shrouded in secrecy, it becomes much more secretive than a terrorist trial or something of that nature.
Collaery's trial will be conducted under the National Security Information Act, brought in after the 9/11 terrorist attacks. The Act allows certain evidence to be heard in secret. As a judge, Anthony Wheely presided over Australia's longest terrorism trial heard under these laws.
I don't think they were designed for this sort of case at all. I don't think they're designed for cases involving whistleblowers, journalists, or the lawyers for whistleblowers. For the life of me, I can't see that this legislation is really appropriate, except in a very minor way, where we're dealing with what are really public interest issues.
The Attorney-General has issued a secret certificate which will likely see key details of the bugging operation suppressed in court. But ultimately, it's up to the judge or magistrate to rule what's made public.
There is a legitimate public interest in knowing what is being tried and what are the arguments that are being deployed for and against the conviction of a person in this position. And that's particularly so where the whole case concerns a supposed or alleged concern that there has been misbehaviour, maladministration or worse, by Australian authorities. Every Australian, I imagine, is interested to know that Australian authorities will be held to account. That's difficult to do if a trial at the pointy end will be held secretly.
Stephen Charles is a former judge of the Supreme Court, who as a barrister represented both ASIO and ACIS.
Very significant job.
He believes key evidence about the Dili spying operation is in the public interest and should be heard in open court.
It is a fundamental aspect of the rule of law that proceedings take place in public. It is difficult to imagine any justification for these proceedings taking place in secret. Everyone who reads the newspapers is aware that ASIS officers entered and bugged the Timorese cabinet premises. Everyone is aware that the result of bugging those premises was that Australia got a huge and very unfair advantage in the negotiations being carried out between Timor and Australia.
Attorney-General Christian Porter declined to be interviewed. In a statement, he said he has confidence the court will strike the right balance between national security and the principle of open and transparent proceedings, and that as far as possible, any legal proceedings in this matter should be conducted in open court. But Bernard Collaery says the NSI Act is already impacting on his defence.
I don't know what I'm going to be allowed to say in court. I've only just been allowed to speak to my lawyers after 18 months or whatever it is. I'm now able to speak to my lawyers, but I'm circumscribed in even what I can tell my own lawyers. It's amazing. It's an amazing experience.
The NSI Act is one of over 70 laws in the name of national security which have passed since the 9/11 terrorist attacks. And many of them interfere with democratic rights and freedoms.
As Australia's security state has expanded in response to the war on terror, so too has Australia's state of secrecy. More government documents are being classified, more journalists are being monitored, more whistleblowers are being charged.
Tonight, the ABC's Sydney headquarters raided by the Federal Police. Officers seized thousands of items relating to news reports from 2017. It's the second media organisation to be targeted after the home of a News Corp journalist was searched yesterday.
I fear we're living in very dangerous times here in Australia. There is clearly a reduction in civil liberties. Whistleblowers are being pursued in the courts. Journalists are being raided. I would characterise it as being in a pre-police state, which left unchecked will get even worse, and one day we'll wake up and wonder how on earth we got here.
Laws have been passed that can make any work you do affecting Australia's economic activities, espionage, sabotage, conspiracy. There are new laws that have quietly slipped through, basically unquestioned by the opposition.
The country generally should have a good hard look with no preconceptions about just what is the scope of information about government that should be kept secret from the people. For how long and why? I think that for far too long there has been this notion that a very few people will decide what's good for us to know and what's good for us not to know, and I, for one, am not prepared to give them a blank cheque.
I've got no doubt that if the public of Australia believed that the national security legislation which has been passed into law would be utilised in this way, to raid the ABC, to raid News Limited, to take action against a tax office whistleblower, and to also, in this case, in Bernard Collaery and Witness K, to take action for people who, in all conscience, were ensuring that democracy was upheld. I don't think people would accept it, and nor should they.
And the other thing that happened with this case...
Senator Rex Patrick and MP Andrew Wilkie are pushing for greater oversight of intelligence agencies and legal protection for whistleblowers.
Some of the changes we'd like to see is the ability for someone to blow the whistle anonymously. We'd also like to see changes where if nothing is done after the whistle has been blown, people can go to either the media or to a politician.
It's way beyond time for a government to go back and revisit this and to create effective whistleblower protections so that insiders, including security insiders, If they are genuinely witness to misconduct, they can speak up, and if need be, they can go to the media.
Bernard Collaery will face court again later this year, in what could be a long trial. If found guilty, he faces up to 2 years in prison.
The prosecution or the persecution of witness K and Bernard Collaery should be discontinued immediately, because it is not right under any law to pursue people and charge them when all they have done is told the truth. Those two men told the truth about what we have done. The people who did the fraud, the illegal fraud, the spying, the low-down action against Timor, they've got away with it. They're not being charged with anything, and they should be. And here we have two truth-tellers who are now being charged.
Timor-Leste's former Prime Minister, Xanana Gusmao, wants the Australian government to drop the prosecution. If it goes ahead, he says he will come to Canberra and give evidence in court on behalf of witness K and Bernard Collaery.
My message is only an appeal. Please, drop the issue. Please. Because I will always be on their sides. That's why I already promised to them, if it was not a secret trial, I will go to be a witness.
And what kind of evidence would you give?
All the information that I know.
And is that evidence that the Australian government may not want to hear in court?
Maybe.
So are you saying some secrets that may embarrass previous governments?
I believe so.
I got your folders here.
Thanks, Matilda. And can I have my phone too, please?
No worries.
Thanks.
Bernard Collaery has prepared for trial many times before, but never for one like this. When he appears in the ACT Supreme Court, it will be for the first time as a defendant. With the full force of the Commonwealth against him, it's shaping up as the fight of his life.
Well, my practice earnings have crashed. It stopped my practice in the Superior Court, effectively. It's the effective end of my career.
Are you able to tell us how this prosecution has impacted on witness K?
I don't dare answer your question because I might pour out a torrent of heartfelt views. I want to say this. When this is over and dusted, I will have a lot to say. I will have a lot to say. And we live in a country that understands the boomerang. There's a boomerang out there. It's going to come back, regardless of that outcome.